All right, so you have a trust. You are awesome. You're on the right path to have a smooth, efficient, and effective estate plan, okay? Now, one of the most important parts of having a trust is making sure that the assets are actually titled in the name of the trust. Let's face it, your trust is not reaching its full potential unless the assets are titled in the trust. So let's talk about how to get that done. Different assets are titled or funded differently into the trust. Now, I used a word there, funded. Attorneys, we call transferring assets into your trust funding the trust. Now, I always refer to a trust as a bucket, and it's a bucket that you create while you're alive. And when we put the assets in the bucket, the trustee's holding the bucket handle and those assets in trust for your beneficiaries, okay? So that's how I visualize it. And when we put those assets in there, that is funding the trust. Let's talk about different types of assets and how we get them funded or titled into the trust. So number one, real estate. This one's huge because real estate is always going to have to go through probate upon your death, unless it's in a trust. Okay, I'm going to back off that one a little bit because there is a way, if you hold property jointly with the spouse, for example, if one of you passes away, the other spouse is automatically, without probate, the owner of the property. Well, there's no probate for that. But when the second spouse passes away, there is a probate to transfer ownership of that. So it's better to title the property in the name of the trust. So how do we do that? To transfer real estate, you need to sign a deed from your name, which conveys ownership of the property into the name of the trust, the trustee of the trust to be specific. And then we file that with the county recorder where the property is located. That's how you get real estate in there. Your attorney can help you do that. Sometimes a title company can help you do that as well. What about personal property? This is your stuff. This isn't accounts or real estate. This is just your stuff. How do you get personal property into the trust? Probably the easiest one of all. When you sign your trust, you probably did, along with that, and if not, your attorney should help you with that, sign a general assignment of assets, which basically declares, I've created this trust and I hereby assign all my stuff to it. That includes your stuff, the couch, the piano, your personal property, and things like that, which don't have a title ownership, like real estate or cars or accounts, things like that. Well, let's talk about that. Cars, vehicles. How do we do that? It's not that complicated, but you can go to your Department of Motor Vehicles and change title to your vehicle into the name of the trust. There's no probate to transfer up to 4 vehicles upon your death in the state of Utah, and in most states that's very similar. So while you may transfer ownership, in a lot of cases it's fine to just leave them in your own name. What do we do about life insurance? So life insurance, there's 2 things that we deal with: ownership of the policy and beneficiary designation. Now, in every case, we always want to have a beneficiary named for your life insurance policy, because if we don't, there will be a probate to receive those funds and transfer them to your heirs and so on. Your beneficiary should be your trust in almost every case, okay? You can change that by requesting a change of beneficiary form from your life insurance agent or company, or if it's a policy through your employer for an employee benefit, you can work with your HR department, and sometimes you can log into your account and change the beneficiary for those. So that's how we change beneficiary. What about ownership? And why and when would we want to change ownership to a life insurance policy? Well, more often than not, you won't change the ownership. It's okay to leave it in your own name. However, in certain circumstances, and I advise clients on this, there is a particular reason why we want to change the ownership of the policy. For example, we're transferring the policy into an irrevocable trust, like an irrevocable life insurance trust, for estate tax planning to get the value of that life insurance policy outside of estate tax exposure. Okay, what about personal bank accounts? Personal bank accounts, similar to life insurance, we can change the ownership or the beneficiary designation. Now, you could go to your bank and request that they change the owner of your bank account to be now your trust. So your account will be in your trust. You'll need to provide a copy of the trust itself or a certification of trust and sign some paperwork, and they'll do that. Now, depending on your bank, this may or may not change your account number. They can work with you on that, and that may depend on if it's a revocable or an irrevocable trust and so on. In most cases, you can simply just request that your bank name your trust as the pay on death beneficiary, or pay on death POD. So you have a POD designation on your account. That's really simple to do. You just go to your bank, request that the trust be named as the pay on death beneficiary of your account. What that means is, upon your death, when they're shown a death certificate, they're going to close your account out and they're going to transfer the funds to your trust. Now at that point, your trustee is going to need to open up an account if there already isn't one in your trust name. But at least there's no probate to get it there. And in the meantime, you can keep your accounts the way that they are, in your own name, don't need to change anything, and upon your death, they transfer without probate. What about investment accounts, your brokerage account? I recommend doing the same thing as your personal bank accounts for those. Now, in some cases, I might advise clients to change ownership of investment accounts, but that may be because there's a specific trust that I want to own that account, like an irrevocable trust for some reason. Retirement accounts, IRAs, 401ks, 403bs, those types of accounts, like life insurance, those name designated beneficiaries, and you always need to have a beneficiary named for your retirement accounts to avoid probate. And there's also some tax implications with these. So if you, more often than not, you're going to name spouse as a primary beneficiary of your retirement account and children as the contingent beneficiary. Now, some of you may not be married or may not have children, and so you might have different beneficiaries, but you're generally going to name an individual as the beneficiary of that for the efficiency of stretching the tax deferral on those accounts after you pass away. You can name a trust as the beneficiary of those accounts, but you may or may not lose the maximum stretch potential of tax deferral. So you're going to need to talk to your attorney to understand what's best in your circumstance and why that may be. But that's how you do it. You change the beneficiary of that, and you can request your retirement account administrator, that might be your employer or your investment advisor, for a beneficiary change form to do that. Now, business ownership is another thing that you want to change to make sure that there's no probate upon your death to transfer your ownership in your business to your trust. The way we do that is you can update the business documents. Now, different types of businesses are going to require different business document changes, updating the bylaws or updating the operating agreement for your LLC, for example. There's several ways to do that. So depending on the entity, whether you have multiple owners and it requires approval of the others. So that's something that your attorney can help you with as well. And I hope this has been helpful. Your attorney can help with some of these things to get assets into your trust. Again, it's very important to do that so that your trust reaches its full potential. Some of these things you're going to need to do some legwork on your own, always hopefully subject to the guidance and instruction of your attorney. Your attorney can prepare deeds for you and help get those filed with the county recorder. They can help update business ownership documents. Your investment advisor and your insurance agent can help you change beneficiary and ownership of your policies or investment accounts. And your personal banker can help you change the ownership or pay on death beneficiary of your bank accounts. So if you have questions, ask your attorney, reach out to us anytime. We're always happy to help. So remember that your trust does not reach its full potential until you transfer all of the assets into the trust. Keep watching for other videos. We hope we've been helpful.